Good evening. This is John Milburn for Laws 11059, Statutory Interpretation. We're into week 10. We're dealing with statutory presumptions, but on the 5th of February, we have our ProctorU examination. And tomorrow, I hope to be advancing my discussions with ProctorU. In the meantime, certainly Sarah and Sharon have been attempting to register and in fact have registered. So Sarah, if you'd be kind enough to take us through the steps that you had adopted, and hopefully we can see if we can manage you to share the screen.
Okay, so first up, just a quick question about logging in. So you go to the ProctorU website and then you have to create an account with ProctorU. So I just use my CQU email and a password. And because it asks you to fill in details with regards to your university enrolment, what a university and your name and such like that, it finds what sessions you have up to. So it finds you in their register for ProctorU because this course has been registered at ProctorU. So it can say that, oh, I'm enrolled in this course and I'm registered to have an exam for ProctorU after I finished the registration process. Because you can't automatically log in, it asks you to register your account. So if you register your account when you go to the website, it'll bring up a screen like this. I'll share the screen, you should be able to see it. Okay, so you should all see this is the ProctorU homepage after you've logged in. And it shows you if you have questions for testing your equipment and schedule a new session. If I click on schedule new session, because it says I have no session schedule, I pick my university, I select a term, there's only one available, and then I select the type, there's only one exam because there's only one ProctorU exam for this university, as far as I'm aware. So we select that, then click find session, and it brings you to this session, this page, which is where you schedule your sessions to pick when you will have your exam. You're supposed to click on the day. It's all the same day, so that's not an issue. And then you're supposed to select a time. It tells me in WA time, so it should tell you local time, what time the exam is supposed to be. This says it should be between 2 and 6. So if I select 2 p.m. And click find available times, it's supposed to bring up a schedule session, but the issue at the moment is this is what it brings up. It's blacked out, or the exam time would extend into a blackout. So it's not letting us schedule any sessions. I've tried. If you don't go within that time, you just get this time selected is not available.
Thanks, Sarah.
So after you set up your account, which it takes you through step by step, you get to that page. So we just need to sort out the session times for everybody to register.
Excellent. All right. Thank you very much, Sarah. That gives me something absolutely concrete to go back to ProctorU tomorrow, hopefully. And bear with us. If we can't resolve this until next week, I'm sure we'll still be able to sort things out. The process behind the scenes is well advanced. The examination should take 2 hours. If you have any special needs or you need special consideration, would you please send me an email? For example, I'm going to include an inquiry made, I think by Gary, who said he wanted to use voice recognition software, as I would if I was doing an exam of this type. And I'm happy for people to type in whichever way is acceptable. So if you want to use the keyboard, that's fine. If you want to use voice recognition to produce your response, that's fine by me as well. Does anyone have a problem with that approach? Okay, so if you have any sort of special needs, whatever that might be, please let me know. And you won't be able to apply for an extension in the ordinary manner because that only applies for 24 hours in advance. Okay, so I'm not sort of saying I expect that you need to have special exemptions, but just in case there is. All right, well, thank you for that. Sarah, the other thing is that your results for the second assessment are well advanced overall. The work that I've seen is very good. I'll provide those responses to you in the next 48 hours, I expect. So again, a little past the time that I would like to get feedback, but it's on its way. Excuse my voice. I've been doing a lot of talking today. So onto the topic for this evening. We're talking about statutory presumptions. Just a question for you generally, and that is, did you work on trying to incorporate the issue of statutory interpretations into your personal toolkit, which was the first question in assessment number 2? Or did we gloss over that? So you can just type a yes and no, or you can unmute your microphone. Did you incorporate statutory presumptions somehow in your flowchart, in your toolkit? Not seeing any answers yet. No.
Yes.
Yes.
Yes, I think I did.
Okay. Yep. So
I think I looked at them, but I
yep.
couldn't incorporate them due to lack of word count.
Yes,
I ran out of words.
Word count was always an issue, and because I set the parameters on the basis that I want a toolkit that works for you, then of course there's a fair degree of subjectivity in terms of what actually does work for you. But the point that I'm trying to make is this: when it comes to issues to do with, say, toolkits, the ones that, for those of you that did Introduction to Law with me and now Statutory Interpretation, this is meant to be a live document. My intention is that we set a task for you as an assessment piece that is a living document. I really want you to adopt this for your own studies into the future and also for practice that you might have. So feel free now, even though you were constrained on a word count, to expand on that, change it, and make it something you actually use. So if you're dealing with, say, a contract problem, or you're dealing with an administrative law problem, or whatever it might be, I would expect that almost as a matter of course, you would go to your toolkit and say, okay, there is a statute involved in this problem. Let's just run through the toolkit almost like a checklist and make sure that you pick up on something that you might otherwise have not picked up on had you not used or referred to the toolkit. So David, any thoughts?
I was just going to say, I kind of touched on it, but without having read this week's material, I realised that it was probably more in a philosophical way within my toolkit rather than the nitty-gritty that we'll be looking at this week.
Okay. And how mean of me to ask if you've incorporated something in the reading from week 10 into the assessment that was due in week 8. But that's just the way it is. You know, it's reading the act as in its entire context. It's a little bit like that with this subject, isn't it? That you receive your text, you receive Sanson. You know, how do you go about doing your studies? Do you start at page 1 and read and peruse carefully? Or do you pick up the text? Do you flick through the chapters? Do you get a feel for the headings? Do you get an idea of the context and the purpose of the text and then start to read? Reading the text, in other words, is somewhat similar to the process of reading legislation. Anyway, that's what I would suggest. Those of you that incorporated something about statutory presumptions into your flowchart, good on you. If you didn't, don't worry. There are many things that you could incorporate into your flowchart, but tonight we'll be talking about statutory presumptions. And as we do that, I want you to consider how you might incorporate statutory presumptions into the flow of the material. How does it actually fit in to the overall concept of statutory interpretation? So, common law presumptions, of course, come from the common law. We all know what the common law is. In essence, I guess, in this context, something that's not statute. So, and a common law, of course, we know that Parliament can override the presumption, as in case in any common law rule, through legislation. So, a common law presumption would be, by its very nature, rebuttable through the introduction of legislation. Do you accept that concept? So if you're going to rely on a common law presumption in your flowchart, you'd better put in an arrow or do something to say, has this been overridden by legislation? If so, what do you do? If it's been overridden by legislation and it's there are clear words in the legislation saying the presumption doesn't apply, to what extent does the presumption apply? Can you give me an answer? You can give me a percentage if you like. I'm not seeing any responses yet. Somewhat is the vote.
Isn't it? Is it though, when there's clear words that it overrides, that it is completely rebutted?
So Tanya says 0.
Yeah.
So, okay. Sarah says a little bit. Any other thoughts? Okay. So I would have thought it's 0. I would have thought it's 0 because if Parliament can override the statutory presumption, then it's rebutted. But only if it's clear words. What if it's implied? What if it's an implication that you might argue? Can you rely on the statutory presumption then if you're arguing that through this legislation it was clearly implied that Parliament intended to rebut the common law presumption? Michael says no, you can't rely on it. Okay, we're afraid to vote now. Can only argue, may be persuasive or relative. Yes, in some cases. So again, it comes back to that toolkit. So if you're going to argue for a statutory presumption, you need to ask yourself, has it been rebutted? If so, has it been rebutted by clear words, or we say clear implication? I guess the clear implication bit is a little grey, but look, if you're arguing that it must have been rebutted through clear implication because otherwise the provision would be meaningless, then I think you could argue persuasively that the court ought not consider the presumption at all, even where there's a clear implication as opposed to clear words. Did anyone see a case that might support that type of argument? It's a really good one to keep up your sleeve when you're considering statutory presumptions. I'll give you a hint. It's in relation to authority to enter or remain on private property, whether that was clearly implied or intended through the legislation. Anyone come across that case? High Court decision in the 90s. I'm giving you a chance to look it up in your text or otherwise. All right, 5, 4, 3, 2, 1. Coco against the Crown, 1994. Jess got it just on the buzzer. Well done, Jess. All right, so keep that case up your sleeve because it is a handy one when it comes to dealing with presumptions. So what we're suggesting is that when it comes to a common law presumption, Parliament can override that. Ask yourself whether Parliament did so by clear words or by clear implication, in which case, arguably, the presumption makes no difference to your legal position at all. But if it comes to a common law presumption, generally speaking, the key word is clear. I'm suggesting clear words and a clear implication would be sufficient to ensure that you don't rely on the presumption, but it's got to be clear, one way or the other. Because some of these presumptions are very powerful, aren't they? Can anyone give me an example or a couple of examples of statutory presumptions or common law presumptions? Any examples? What are some of the presumptions of interpretation?
Is it like legislation doesn't have extraterritorial effect?
Yes, that's a good example. Yep.
They do not conflict one another.
Yes, that's it. That's good. Any others? Legislation. Melissa's come up with an interesting. Legislation doesn't bind the Crown. Depends where you are. We'll come back to that. Yes. Is anyone from South Australia?
I was going to say it's a South Australian one, that one.
Well, it is. Yeah. Why is it different in South Australia? Oh, you're in Western Australia, aren't you?
Yeah, but the writers stipulated it in the legislation.
Yes. So in South Australia, the Acts Interpretation Act says that the presumption is that the legislation does not bind the Crown. It's the opposite in Queensland. And I think the opposite elsewhere. I think it's only South Australia.
Yeah, in the book.
Jess says legislation doesn't operate retrospectively. Yes. So these are all presumptions that you that we're considering, and some are very important. And they rely on rules of law, sanctity of private property, and the concept of freedom of the individual. So, in other words, it has to be clear. 244 for the list. To 245 says Michael. So thank you for that. One good example of that is self-incrimination. There's a presumption that people can avoid making a statement if to do so would create a situation where they have incriminated themselves. So if that common law principle is to be overtaken by legislation, it would need to be very clear and unambiguous words from legislators. So in that instance, it might have to be clear words rather than necessarily just a clear implication. So I'm making some distinction between clear words and clear implication. That may in fact not be the case, but I think it is. All right. So Mary says rebuttable or decisive presumption created by statute, it does not shift the burden of proof. Yep. Okay, so thinking about your flowchart, how and when do you apply these presumptions, these statutory presumptions? So last week we talked about some of the principles of common law and how the statutory interpretation principles have developed. So this is really following on from that a bit. And given the modern approach that we've been teaching from the start, I mean, is there a place for statutory presumptions in light of the modern approach?
I think there is, because it can help you determine the obiter of the case that you could potentially be at, or your client that you're advocating for. So when you're looking at legislation and applying everything that we've just spoken about, it can actually help you to determine the obiter in terms of what course of direction you're going to take in your advocating for your client.
And I think that's a valid point. I think when you're looking at, for example, the explanatory notes or explanatory memoranda, you're looking to try and obtain some idea of the intent, the purpose, and the context when you read the legislation. So the presumption might colour that by material in the Act itself or through extrinsic material. So, yeah, in order to determine whether the Act provides for a clear implication, sometimes you need to actually consider the statutory presumption. So I think it can apply. And if it's evident from the text or the context or the purpose that an alternate meaning should be used, then the statutory presumption, may not even be relevant. So sometimes it's a matter of determining, firstly, the modern approach. Is it clear from the text, the context, or the purpose? Are there clear words? Is there a clear implication? If so, you probably wouldn't go to the statutory presumptions or the common law presumptions. But if there's some doubt, then as David suggests, you need to look at that in order to get a better idea and indicate how the legislation came into being. All right, so I'm not sure I explained that very well, but we'll think about that in the context of your reading and try and work it into your flowchart, as I mentioned. So sometimes there are long-standing expressions of common law, and courts will, if there's something which is perhaps technical or there's some reference to a long-standing principle of common law, then generally speaking, the courts will presume the common law meaning applies unless the context suggests otherwise. I know what you're thinking. This becomes a bit circular because on the one hand, I'm saying if the context is clear, you don't need to worry about the presumption. But sometimes you need to consider the presumption unless the context suggests otherwise. And it all comes back to that issue of whether it's clear. If it's not clear, then in my view, talking about the presumptions is certainly available to you as part of your argument. So what are some of the presumptions? As Michael said, have a look at page 244 and 245 of your text for a list. But, for example, there's a presumption that Parliament does not intend to interfere with vested property rights. Native title is presumed not to be extinguished by legislation except by clear and plain intent. That wasn't the law in the 80s, but it is now. And it's presumed that crimes have some form of mens rea. So all of those things are presumptions that would generally apply in the context of legislation unless there are clear words to say don't apply them. Someone mentioned extraterritorial effect, and usually there is a presumption that legislation does not have that extraterritorial effect. But are there any exceptions to that? And if so, where is your authority for that proposition?
That's the line between New South Wales and New Zealand, isn't
it? Yeah.
I'm
not sure about that. It's not the answer I'm looking for.
Okay.
I'm looking for something actually very specific. Sorry, I'm quizzing you a bit tonight. So what we're saying is there's a presumption that legislation does not have extraterritorial effect. If we accept that as being a proposition, my question is there an exception to that? Because I'm really saying that's true, but usually it doesn't, but there is an exception.
Going again now, is this the property in Europe? And it's under the...
Could be.
Yeah, I've read it in here. I'm just trying to find it.
Okay. Thomas has the New South Wales Crimes Act, Section 10A. I'm actually not familiar with that. That's not one that I'd come across. But do you want to explain that further, Thomas? You don't have to, but if you do, that'd be good. All right. And Tanya says, is it Pleiades against the Commonwealth? All right. The answer I was actually looking for is the Commonwealth Acts Interpretation Act. I think it's Section 21. Melissa's got it. 21B of the Acts Interpretation Act, Commonwealth. So what it says is that legislation can have extraterritorial effect if rebutted by clear words. But again, it comes back to that's the word, clear. Have a look at Section 10. Michael says Brian and Doyle, not familiar with that one, but feel free to unmute and elaborate if you wish. Okay, so we talked about South Australia before, and we talked about legislation binding the Crown. So generally speaking, legislation does bind the Crown, but in South Australia, that is not the case, unless stated otherwise. So, for example, in Queensland, we have Section 13 of the Acts Interpretation Act that says that there is a presumption that legislation binds the Crown. Okay. Now, there are some other things that you want to keep in mind. For example, generally speaking, if there is a provision that is remedial or a beneficial provision, courts will broadly construe that. So the courts will construe the beneficial statutes towards the greater benefit to the individual. So that works a little bit in terms of, say, income tax legislation or things like paid maternity leave. So the courts will be quite liberal in the presumption that they make about that to benefit the individual who is supposed to benefit from these things. And sometimes statutory and presumptions have been recognised as fundamental rights. For example, well, what's a good example of a fundamental right? We think back to the rule of law. Can you think of any fundamental rights? Right to silence, right to legal representation. Yep. What about the presumption against retrospective criminal laws? That's a pretty important one, isn't it? We don't have a Bill of Rights, but there is the presumption against criminal laws having retrospective effect. Some of you referred to a case which I think is another handy one, personal liberty, says Sharon, and this is another handy case to have up your sleeve in this area of law. Some of you referred to it in your toolkits. It's the case of Malika Holdings against Stretton, 2001, 2004, 2004 CLR 290. So in Malika case, the High Court recognised that the right to against retrospective application of criminal law is itself a fundamental right, and that was supported in the Keating decision, 2013.
Can I ask a quick question in regards to criminal law and statutory? You mentioned mens rea before, and in regards to presumption, is there any time within criminal law when mens rea isn't regarded anyway? I thought it's almost a necessity.
Trying to think of an example. Sometimes there are reverse onus issues that might apply. Sometimes there are specific provisions that deny people what would otherwise amount to a defence. An example of the first, which is providing for reverse onus, for example, would be under the Drugs Misuse Act in relation to offences where a person has drugs on their property. The presumption would be that they knew about that. They would have to reverse that presumption if they were going to succeed. An example where some of the basic defences would not be available would relate to, say, drink driving, where if you are over the limit and you didn't intend to go over the limit, in fact you thought you were under the limit, you can't rely on a defence of honest and reasonable doubt, at least in Queensland. So I'm not sure they're good examples, David, but they're the best I can come with from the top of my head. But it's a good point.
Thanks for that.
No, thank you. Okay. So I've talked tonight about how you might deal with these presumptions in your toolkit. Perhaps what I will do is just digress a little bit and talk about the toolkit. In a way, I was a bit mean by saying 5 steps, because arguably there's more than 5 steps. You could easily go to 8 or 9 or 10. Did anyone have difficulty in trying to squeeze it into 5? Yes? Okay. So now that you've put in your assessment, feel free to break that down and make it 10. In other words, 5 was just an arbitrary number. There's no specific reason why it's 5. You could say it's more than that. So let's run through, say, an idea of what might be in a toolkit. A lot of you said that the first thing you've got to do is identify the legislation and the issues relevant to the problem, and that's correct. But you've got to consider whether the legislation existed at the time and whether it had, the potential to deal with the issue. I guess the next step was one of jurisdiction generally. So in the assessment, did anyone pick up on the fact that this in the problem solving number 2, when the idea was that you prepare your toolkit and then you solve the problem using your toolkit. That was kind of the idea of assignment 2. You probably picked up on that. It was pretty obvious. So when you're going through your toolkit, you're thinking about issues to do with jurisdiction. Does the legislation apply? Did anyone pick up and think, well, maybe this event occurred outside territorial waters and we'd need to get some evidence from the client and others? Just an idea. So on the question of jurisdiction, you've got to make sure that it has geographical jurisdiction, it has temporal jurisdiction, it has constitutional jurisdiction. So there are a few different sorts of issues to consider there under the heading of jurisdiction.
I don't remember what it was, but I found a piece of legislation that said where a jurisdiction covers a state, it also applies to its coastal waters.
Okay. Yep. And of course that's good, Jess. Because some of you might be saying, yeah, but you said don't use any legislation that's not the Acts Interpretation Act. So it's sort of like a general thing. But if you found something, that's very good.
Yeah, it was in the Acts Interpretations Act. Yeah.
Yeah. Okay. Thank you, Jess. So Sarah said, are there any marine parks in extraterritorial waters? That's a good point. But, it's one of the first things I think about if it's where did this event actually occur, and do the regulators have authority to deal with that issue? Mary says, well, it was a fake act, so there were many assumptions that could be made and thoughts. Part of the exercise of preparing the toolkit for future use is to give you a chance to ask the right question. Now, if you're dealing again, say, with a contract issue, if you're talking about legislation, maybe contract's not a great example, but if you're talking about legislation, you've got to ask yourself that jurisdictional question: where did this event occur? Where did the contract actually exist? Does the Act have jurisdiction? Don't assume these things. And sometimes the examiner might be throwing in these things, hoping that you will pick up on these questions. And sometimes all it takes is for you to say, I'm working on the assumption that this event occurred in Queensland, but I'd need, in practice, I would need to obtain further material and ask further questions or do something along those lines. So just give a hint to the examiner that you've picked up on the issue of jurisdiction, which is possibly step 2 in a toolkit. So step 3 might be, an overview. We've always said statutory interpretation, you've got to look at the big picture, understand the legislative context, identify the relevant provisions, and look at, the objects, have a look at the definitions. Before you even do that, have a look at the headings. So getting that overview is probably, a third step. I'm going to go beyond 5. 4 is, well, what's the next thing you would do? You've found the legislation, you've checked the jurisdiction, the threshold issues. You've then had a look at the overall picture. What are you then looking for when it comes to statutory interpretation?
Does it provide clear meaning?
Yes. And when we say clear meaning, we would start from the perspective of ordinary meaning, wouldn't we? Yep. So meaning is and when we say meaning, Jess has got it, and Michael, meaning within its context. So meaning of the provision in its context is sort of the phrase that we're looking at. So context and then purpose. But we'll come back to purpose because I've got that as sort of step 5. But just in the issue of ordinary meaning, well, number 1, you have to read the provision carefully, but you don't just dive into it. We look at the whole thing. You've then got to look at the elements of the legislative provision and identify key words. In the work that I've seen, most of you did a very good job in identifying in the fake legislation, key words or key phrases, and actually highlight that, put it in italics, put a single inverted commas or do something. Once you've found a key word or a key phrase, and you think that will be relevant to the ordinary meaning in the context of the provision, what's the next thing you do? No, we haven't got to purpose yet. We'll come back to purpose. But just in terms of ordinary meaning, what's the next step? It's still part of step 4. In order to find out its ordinary meaning, we look at definitions, don't we? So we look at the definition provisions and we consider whether the dictionary, have a look at adjoining provisions as well. Consider the extrinsic materials. Probably that's a little bit further down the track, but that is true, Jess. You would certainly do that. But initially, you would have a look at those rules about meaning. And I guess when you're looking at extrinsic materials, yeah, you would look at things like explanatory notes, etc. Okay, so that's the ordinary meaning of a provision within its context. So let's say that's step 4. Step 5 would be purpose. Michael mentioned purpose. I think somebody else mentioned purpose as well. Just going back one step, Michael says, if there's more than one meaning, what is the broader meaning? I'm not sure what you mean by that, Michael. Did you want to elaborate?
That I've just got, well, if you go into the dictionary trying to find the meaning, you know, what is that exact meaning? Is there more than one meaning? And then which is the one most likely and which is the broader meaning? So. Okay.
Yep. No, that's a fair comment. All right. So purpose. So a few of you have said, all right, well, after you've dealt with the issue of context, you've then got to consider purpose. I mean, at this stage, you'd have to bring in the Acts Interpretation Act somewhere, wouldn't you? I mean, you've just got to be really careful to look at the Acts Interpretation Act. Dictionaries within the meaning of the Act, yep, says Marianne. That's important as well, or Mary. So have a look at the purpose. We're primarily looking at intrinsic aids, but then we'll also look at external materials, which might even not necessarily answer the issue, but it might confirm. So add more weight to your argument by saying, this is, based on the intrinsic materials, in my submission, this is the meaning, this is the purpose of the provision, and that is supported when we look at the extrinsic materials. Okay, so number 6, you may have to look at what courts have said. Has that legislation been interpreted judicially? That's your legal research skills. That's looking at Note Up, for example, looking at case citators to see when and to what extent and how did courts look at that provision. And then, of course, if you haven't already done so, step 7, consider extrinsic aids, and then finally reach a conclusion. I mean, there's 8 steps. You could easily stretch that to 10, but the point is that there's not one right answer necessarily. Okay, that's probably all I want to really consider tonight. I'm not sure if people have been looking at the weekly problems still. I've fallen behind in checking those. I guess there's somewhat of a disincentive in the sense that you know pretty much what is going to be in the exam. So those of you that haven't done looked at the draft exam, please do so, and be as prepared as you can for the Proctor U examination. All right, so are there any questions, comments, other issues that you want to raise?
Proctor
Yes,
U, are we meant to log in with our CQU email?
I think, Sarah, is that what you did? You logged in with your CQU email?
You have to create an account, but I created it with my CQU email.
Okay, that's right.
When
Thanks,
you go
Michael.
to the home page, there should be a button up the top right-hand side that asks you to log in or create an account.
Yeah.
If you click create an account, you just choose your CQU email and start from there.
All right, thank you.
Very good.
So basically what you're saying is there's not going to be just like a link on Moodle that we just click. We actually have to go to this Proctor site and log in and do everything that's... we
Yes.
actually have to do that ourselves first.
Yeah. So, Mary, were you here at the start of our session, or did
I
you?
did.
Just...
No, I saw all that. I was there at
Oh,
the
okay.
beginning and
Yep.
all that, but I just didn't want to interrupt because who was it that was doing a great job?
Sarah. Yeah.
Sarah, sorry. I just was a bit confused about whether that was something she did as an optional thing or that's what we actually have to do.
No, I would do that. I'd go on and register. And the idea is that you then, book in a time, but we obviously just haven't opened that up yet.
So what I'm saying is there won't actually be a link on Moodle for that exam. It's going to be up to us to make an account with this Proctor U and then log directly into that, not into Moodle. Is that what you're saying?
Yes, that's my understanding. If that changes,
I'm just
I'll
of
let
the
you know.
generation that's a bit tech challenged, so I need like very clear instructions. That's all.
Oh no, that's fine. And I'm sorry that I'm not in a position where I can give all the instructions, so it's still a learning curve for me.
I mean, I'm still getting my head around Moodle and UCrew and now Proctor U and all that. It's a completely different language. So
yeah. Oh, but we'll get there, Mary. We'll get there.
Can I quickly ask Sarah
Yes,
a
ma'am.
question?
Yes, please.
Can I ask Sarah, when you actually registered and logged in, did they send you a confirmation email or any additional material after you actually registered?
I have the vague impression that I probably got a confirmation email. Let me just check.
Sharon didn't.
Okay, it doesn't look like I did.
So there was no, okay, so obviously if you didn't get that, there wouldn't have been any additional material sent to you in the emails. Okay, all right, thanks.
No additional information.
And I'll keep digging. All right. Okay, any other questions, comments, thoughts? All good? Okay. Yes, Michael.
Oh,
Did
sorry,
you?
I'm all good, thanks. I just
You're all good? Okay, great.
So I'm
Yes, Mary?
just gonna post what I think to be the actual link to the site. If Sarah could just confirm that for me, that would be helpful.
So that was
Is
www.proctoru.com.
Is that the correct place to go?
One moment. Yes, this is the correct place. Although it is my understanding that if you go into the exam file in Moodle, click start attempt or whatever it is, it may take you to the Proctor U website. I went straight to Proctor U because I wanted to have a look around at the website. And then when I logged in to start an account, figuring that I'd probably need one, it just brought up what it brought up. So I was like, oh, well, this is probably what it needs to be. But yes, that's right,
Well
assessment, right site.
Okay, thanks. Thanks.
sorry, what campus did you put, Sarah? Because it's asking campus.
I couldn't select a campus. Yeah, I didn't put anything. I just skipped it because this exam is the only one CQU is doing, and it's all done external. I presume that there's no campus required, so I just went on without it, and it let me keep going.
All right, thanks.
Thanks, Sarah. And Sharon, the trailblazers in checking this technology, so thank you for that. All right, so we've all got some homework to do in terms of registering. I've got some homework to do in terms of clarifying, and I will try to give you some more information over the next day or two.
If anybody has questions like that they want me to answer, you may have a better chance posting on Moodle because I get the emails for that more quickly than I check UCrew. So if you have anything with the registration process and you need to ask me a question, post on Moodle and I'll get back to you as soon as I can.
And I just registered in the last minute. That's how easy it is.
Oh, good. Oh, so you're already there, Michael. Excellent.
Yeah,
Right, well done. Okay. All right, well, we'll wrap it up now. Thank you very much for your attendance, and we'll see you this time next week. In the meantime, we look forward to further discussions and I'll get some feedback and some results to you soon for the second assessment. Okay, thanks everyone. Bye then.